Assalamu alaikum, Honorable Justice Saab, ladies and gentlemen. Nodra, you said that we had the graveyard slot. As the last speaker, I feel that I'm perhaps halfway in the grave. So I'm going to do my best to keep this short. I'm sure the audience would much prefer to hear from learned justices rather than me. So in a room full of lawyers and in a room full of some engineers, but this panel is majority engineers, I'm going to ask the question. In relation to construction disputes, do lawyers cause disputes? I need a yay or a nay. Let's see what I get. Are lawyers the causes of disputes? A yay or a nay from the audience? Yay. Oh, I'm hearing more yays. How about engineers? Do engineers cause disputes? Okay, the yays are louder. Engineers are great people. They build great things, but they also know how to break great things. But sometimes they don't know how to resolve their differences. And I think that's one of the key reasons why we see an increase in construction disputes. Any engineer will tell you the lifeblood of a construction project is cash. Cash is king. But for me, there are two other C's that are also just as important as cash. It's not corruption. That's there. That's an issue. We need to talk about it. But for me, the key things are collaboration, cooperation. If we collaborate, if we cooperate, the culture will change, the culture of project delivery will change, and if the culture of project delivery will change, we will see an impact on disputes. We heard from Engineer Ahmed, who spoke to us about delivery of projects in Qatar. Now, for if any of you who have been to Qatar, you would have seen in the last few years, what Qatar has delivered is remarkable. 8 football stadia, a metro, an airport, and roads. Are there disputes? Of course there are disputes, but not as many as disputes as there would have been had they not implemented a collaborative working environment. And are those disputes getting resolved? Yes, those disputes are getting resolved. How are they getting resolved? Engineer Ahmed talked to us about the various ADR initiatives that have been rolled out in Qatar that are successfully being implemented today. Just touching on a couple of points Nudra mentioned, and I've kind of changed what I was going to say because I just want to wrap this up and talk about 2 key points and leave you then to hear from the Honourable Justice. Nudra spoke about phase 2. Okay, I've got 5 minutes. Nudra spoke about phase 2, which was contracts. She spoke about transaction lawyers amending contracts, litigation lawyers amending contracts. Engineer Ahmed spoke about the fact that in Qatar, they didn't heavily amend the contracts. They didn't create one-sided contracts. They didn't put all the risk on the contractor. The employer didn't say to the contractor, you will do everything, you will take all the responsibility. You are responsible from A to Z for every single thing, and pass that risk on to the contractor. There was a shift, there was a balance in how that risk was distributed. And I would say, as we look to the manner in which contracts are procured for complex construction projects, and we look at standard form contracts, whether it be FIDIC, whether it be JCT, whether it be ICE, the less that contract is amended, the better. That contract has been tried and tested. It's gone through war and peace. It's been administered by lawyers, it's been administered by engineers. You'd like to think that those who have administered it knew what they were doing and know what they were doing. The moment you start tinkering with a contract is the moment that you introduce change and the moment that you introduce people's perceptions. And with perceptions, the risk for dispute increases because my opinion will not be the same as Nasser's opinion and will certainly not be the same as Nudra's opinion, as she is a lawyer. She will look at things differently. We as engineers will look at things differently. Moving on to phase 3, sorry. Experts. Now for me, this is what I love to talk about, expert witness. We're currently working on a dispute in Pakistan, and we've been presented with an expert witness report. And I was reading the expert witness report, which was presented to the tribunal, and the learned expert had given opinion on cost, on time, on technical matters, and they didn't stop short. They had a great opinion on contractual matters, swaying into legal opinion. And for me, that is the problem with expert witness work in Pakistan, and I've seen it on a number of projects, where experts give opinion on matters outside of their expertise. The role of the expert, first and foremost, is to assist the tribunal. The duty of care of the expert is to the tribunal first, to their client second. It is to assist the tribunal with resolving the matter. And if you get two really good experts on a case, more often than not, they will agree things. You may find that slightly unusual, but it happens quite regularly where two experts can reach agreement. Now the CIR, we've spoken about the CIR at length, about the different training initiatives they have, about how it will impact arbitration in Pakistan. A key part of the CIR is they have excellent training initiatives in relation to expert witness. So what we also have the opportunity with the launch of CIR in Pakistan is to improve on our experts, is to ensure that the experts that we introduce to assist in the resolving of disputes actually do what they're brought in to do, assist with giving opinion that will help parties resolve their disputes. So in summary, what I would say, cash is king, lawyers don't cause disputes, engineers don't cause disputes, people cause disputes. People behaviors cause disputes. If we look at our behaviors, if we look at the culture on a project, if we look at how we collaborate on a project, that will help to de-risk project delivery and help to improve project closeout successfully. Thank you very much for your time, and I wish you all the best.